Welcome to Think Smart with TMFG. I'm Mike Connon. This is Carlo Cansino, Senior Financial Advisor of the McClelland Financial Group of Assante Capital Management. Well, today, Carlo, we're going to start talking about a fun subject, estate planning 101, I call this. So a lot of times when we come to these podcasts, a lot of people come in with questions to our offices. And a lot is just some confusion on, people read bits of things, right? Yeah. So they read an article on how to avoid probate, and they think that's estate tax, and they get all very confused in different pieces of how an estate works. So I figure we'll go through and start with simply let's talk about the different parts of what happens when when someone passes away.
Of course, yeah.
So let's talk. I mean, people always talk about probate. What is probate?
Probate, as most may know, is an estate administration tax, acronym EAT, or eat into the proceeds of the estate. And that's typically a tax or fees that the provincial government charges to essentially show that this is the last will and testament and how the will is going to get distributed. So there's a cost in doing that.
Another thing, it is provincial. Yes. Right? So this is where people get very confused and think CRA has something to do with probate. CRA has nothing to do with probate.
No,
this is a provincial cost, and it's different in different provinces. We're in Ontario, so we generally say it's 1.5%. Right. The reality is, I got it here to read, but it's $15. Sorry, it's zero for the first $50,000, and it's $15 in every $1,000 of assets over $50,000. Yeah. Is the technical way how it works. So if you have a very small estate, there is not much probate due. Right. But as estates get larger, it becomes a significant piece. And it's on all your assets, too. So any assets that are subject to probate, it's on your full net worth in there. So it can be a pretty heavy thing. I guess another question, is probate always needed?
Right. And not necessarily. I mean, if you're able, I think the goal would be, Mike, is for people to have as little assets pass through the estate as possible, if they can do so to minimize that probate fee. And there are some ways that you can get that done.
So how can you avoid that, Carlo?
Well, number one, and most of you, if you have your registered investment accounts, whether it be a tax-free savings account, an RRSP, RRIF, you can designate a beneficiary. And when you do so, that designated beneficiary receives your assets upon your passing. And there's no need for it to go through your estate and be subject to that probate fee.
That's a great system. So I guess everyone, ideally speaking, most people should have a designated. If you don't have a designated beneficiary on your account, you just give money for free away to the government.
It's a simple way to just avoid that 1.5%.
And again, that's on registered accounts, right?
Correct.
So just to make sure we know that, that's on, as Carlo said, on any type of registered account. And we have other areas with, if we talk about non-registered accounts, I guess the only way to avoid probate is have something that's called joint tenants with rights of survivorship. Now, just to go into this, too, there's two ways to have joint accounts. People sometimes don't realize. Right. There's joint tenants in common, and there's joint with rights of survivorship. When someone dies with an account that's tenants in common, it does have to be probated.
Correct.
If it's a significant enough amount. If they with a joint of rights with survivorship, it's almost what it says. You have the right to survive, and the money moves over to the surviving person in there, and that can avoid those probate costs many times.
Yes, if there are two people, so if there's a husband and wife or spouses that are joint on a non-registered account, when the first passes away, there is no probate fee on the account. Essentially, the account goes into the name of the survivor. Upon passing of the survivor, that's when you'd have to deal with probate unless another strategy was implemented.
Another thing, small accounts.
Yes.
If you have very small accounts, every institution is a little bit different on what they require for probate. Probate, just to give you a description of probate is usually required by institutions to protect themselves. And the idea is someone could walk into me with a will that says, like John's parents die. He can say, here's everything that goes to me. I'm John. And I can go and give all the money to John. And his sister can come in 3 weeks later and say, this is Jody. And I have a will that was done after that fact that said everything's over to me. And I go, oops, I gave all your money to Johnny when he was in here. And then you have a bit of a problem. And the financial institutions don't really want to be put in that position. Right. So for significant amounts of money, most financial institutions want a letter of probate, which is basically the government saying the will it's been probated, which they give it okay. They issue letters of probate, which means any financial firm can act on those letters of probate. Beyond financial firms, any type of land registry situation also generally requires probate to change name on any lands too.
Right. Right. Essentially, the probate or a probated will indemnifies that financial institution of any wrong distributions.
Yep. And another way to avoid probate is insurance. If you had a designated beneficiary on an insurance policy, again, that does not fall through probate. Many times people use insurance for, I'll say, the confidentiality of it because a will is a public document. So if you leave something to someone in a will, that can be researched and you can find out who got what. If you have an insurance policy with a designated beneficiary, it will go directly to that person. There's really no records of it. It's a tax-free distribution, and people can't go up and say, here, you gave this much money to them. So that's a reason why a lot of people do use insurance.
Ideally, if you have the ability to designate a beneficiary and your will distribution is fairly simple, there aren't any specific instructions in a will that you'd want funds to abide by, then there's no reason not to designate beneficiaries on registered accounts or in a life insurance policy.
So let's move on to the next thing. The next thing is taxes. And again, this is where people get mixed up. They try to consider the same thing. Probate has nothing to do with taxes. They're two totally separate, different issues. Taxes are what's due when someone dies. So you got to imagine that everyone's last words, and I've said this many times, is sell everything I own. That's the last breath you take. Those are your last words. So Revenue Canada designates that as soon as the day you die, everything you own was deemed disposed on that day, and the taxes are due on that day. Now, there are some exceptions to that because within spouses, there's spousal rollovers allowed. So when a first spouse dies, there's usually not major tax implications.
Exactly. I mean, if you name your spouse as your beneficiary on a registered account, the registered accounts essentially will be taxable income in the year you're gone. But if you designate a spouse as that beneficiary, as Mike said, it's the spousal rollover that you take advantage of, and the assets just go into the registered accounts of that surviving spouse without any tax implication. Essentially, you're just deferring that tax bill.
And some things that people ask is, when am I due to do a tax return when a spouse dies? So interesting thing is when someone passes away in a calendar year, it's based on calendar years. If they pass away in that calendar year, you don't really have to file taxes until April, the usual filing deadline for the next year. There are some exceptional rules. If someone dies later in the year, they give you a little bit more time. But essentially, if someone dies in a calendar year, it's just like filing a normal tax return at the end of the year. Believe it or not, it's a lot better, more economical to die early in the year than later in the year. Because what happens if people die in, let's say, January or February, they don't really have any other income. So they don't have any pension income, or they don't have CPP or OAS or anything like that. So usually whatever the state has is the income for the year, and no income comes in after that. After that, from once a person passes away, essentially you have a trust return for any other income earned, which is going to be, they call it sometimes a state return, but it's really a trust return that has to be dealt with too.
Yeah, so depending on how long it takes to administer that estate, it could go into, we've seen in a lot of cases where it could go into the next calendar year and then the next calendar year after that. If there are assets still in the name of that estate or in that trust, then a tax return has to be completed.
There will be a few exceptions with some trusts that people set up special, but that's more of a, let's say, a topic for another day.
Absolutely.
So where's the confusion? There are things you can do to avoid probate, but that doesn't necessarily avoid the taxes. And that's usually the problem we have. People come into the office and say, well, I've read this book on how to avoid probate, and they think that's going to make them avoid all the taxes. But generally speaking, it doesn't do that. No. The other question is, how much should you do to avoid probate?
Yeah, right. Exactly. There are many strategies that you can do to avoid probate, but again, that can invite other issues by trying to save that 1.5%.
The problem is probate is there for a reason. It's to go and establish that the will is correct and everything is done the right way. A lot of times people read an article that comes out in one magazine that will say, here's what you can do to avoid probate. And they go do this. What they don't realize is when they start, usually the way to avoid probate is to start talking about making accounts joint with everyone. And well, it can work out very good and avoid that. In a case where you have different family members involved, everyone forgets that it gets everyone's business wound up with each other. Someone gets sued, gets into a car accident, anything like that. They're not insured. All of a sudden, that becomes an asset of theirs. There's some type of spousal breakdown. It may not necessarily cause problems, but it creates more questions from a legal point of view.
Absolutely.
So you need to be a bit careful when you go to do that. And as we talked about, probate is only 1.5%. And so to go through all this work sometimes to avoid the 1.5% isn't quite worth it.
Exactly.
What about wills? Let's talk about those.
Sure, absolutely.
So if you die without a will, it's called dying in estate, and it's not something you want to do.
No.
So it can cause many problems. We have many articles have been written on famous people that died in a estate, and it causes massive problems in the future and costs a lot of money to get sorted it out. So that's never a good thing. Wills can be very simple to very complex, depending on the situation. And what I find is the best situation is to have your estate professional, your lawyer, match up with your circumstance.
Right.
I know we refer people to different lawyers for different purposes. If there's just a mother and father and they have 2 kids and they're just going to leave it to their 2 kids and they need a will, you can get away with a pretty simple will.
Sure.
And that shouldn't be too expensive. If you have someone that's on a second marriage and they own a company and there's multiple sets of kids involved, that gets very complicated. And again, that will is not going to cost you, $500 or $600 set up. It's going to be quite a few $1,000s to have something to take care of that situation. So you need to make sure you match the complexity of your situation with the experience of the professional you're using.
The costs that you have with setting up the will can save thousands, hundreds of thousands of dollars if the will isn't set up. I mean, there are so many different services that you can use to prepare wills, whether it's online or a template. But if you have a complex will or a complicated situation and they're not set up in the right way, you could be losing thousands of dollars where it would have been worth it just to have that professional do it in the first place.
I mean, anyone can chat GPT a will now and have it done. It's very easy to have it done in 3 minutes for no cost. But it's very simple. And if your situation is anything beyond simple, we suggest you go to make sure you have the right professionals in place. What about trusts? So trusts are one of those things. Before you get into the whole trust thing, I always think you should really understand the size and the complexity of your situation. Some people get into the idea and to save some money in these trusts. And the problem with trusts is, number one, they're expensive to set up.
Yes.
Number two, they're expensive to administer in the future. And if there isn't a significant enough savings in getting this set up, it may not be worth it. Trust can also be very good for situations where people are not great with money and they need to help them in the future, or anyone with a disability. There's things called Henson Trusts to take care of things like that. So they're a very important part of estate planning, but you just have to make sure that your situation requires that.
I look at trusts in one way when it comes to estate planning, is the deceased or the people with the wealth that they're distributing use trusts to be able to still have control over the assets and how they get distributed. You'll typically see in a will where if there are minors that will inherit some wealth, it's going to be in a trust until age 18, 21, 25, in some cases 30, where there can still be instructions for the trustee to abide by to distribute the assets to the end beneficiary. That way, again, to what your point was, Mike, if there are people that are inheriting money that may not necessarily be good with handling that sort of money, having a trust in place can definitely get your instructions or your wishes across.
The more clear you are, the better.
Yeah,
right? Because
yes.
Be clear when you're alive, because you can't be very clear when you're dead.
Yeah, exactly.
So what do we learn on this? Estate plan is something everyone needs to address.
Right.
That's the number one thing. So everyone should look into this and make sure their situation is taken care of. And I think the other thing we sort of took home is make sure the professionals you're using really match your situation. And if you have a complex situation, it's going to cost some more money to have that estate planning work done. But will it save you money? Yeah, it's going to save you a lot of money in the future.
Yeah, definitely.
Thank you. That brings us to the end of this episode of Think Smart with TMFG.